their academic life, both of them became very close friends and later expressly agreed to marry each other after settling in life. And once they have and this fact was also known to both of their families because once they had made the promise, both of them started living like a husband and wife. And once they had finished their law degree and they settled in law practice, both of them jointly purchased a house and lived together. And in early 2025, after the advocate to him, he mentioned that he would not be marrying him. This fact broke. Later on, she filed a FIR before the Guntur police under Section 69 of BNS. And the same for same charge, Wicket was tried by the Sessions Court, which made a reference to the High Court under Section 436 with respect to the redundancy of Section 69. And the High Court answered affirmative to the reference question, and due to the same, under the accused was acquitted. Now, agreed by the acquittal of the accused, advocate preferred appeal to the High Court. And during the period when the appeal was admitted before the High Court, an NGO called Women's Power declared a petition with respect to constitutionality of Section 69 of BNS. Now, understanding the importance of this matter, we can file a transfer before this honorable court, and this honorable court accepted the transfer and has posted for arguments before this honorable bench. If you are also satisfied with the fact, the council seeks permission to move on with the issue. The Lordship, the council will be dealing with 41 in respect of principle of shared decision and it reinforces principle of judicial uniformity.
Any question of constitutional law is pending before a High Court.
Indeed, yes, Your Lordship, but it depends, Your Lordship, because the council is well aware of the fact that High Court is competent constitutional court that can decide validity of central law. However, Your Lordship,
Three conditions.
indeed, yes, Your Lordship.
If those conditions are complied with, the Supreme Court can accept transfer of cases from the
Indeed, yes, Your Lordship.
all
Not disputing that, and that is the very reason why the council stated their submission, saying that the transfer jurisdiction of this honorable code was invoked documented under 139A. The council is aware that the pre-requirement under 139A is that there must be some sort of parallel proceedings or similar question of law that must be pending before different High Court and the Supreme Court in itself. However, Your Lordship, there is also an additional factor of 446 in BNSS which gives the power to this court to transfer cases and appeal, Your Lordship. And when was 446 of BNSS, Your Lordship? 446 read with 138A documentally provides inherent jurisdiction of this honorable court to entertain this matter, Your Lordship, because Your Lordship, it must be noted that Section 69 is a newer penal provision and it did not have any concurrent or parallel provisions with respect to IPC, Your Lordship. So, such a new penal provision, if its constitutional validity is settled by the apex court in itself, it will prevent fragmentation of law if multiple High Courts decide the question of constitutional validity of Section 69. That must create a fragmentation of law because when a High Court sees on such a constitutional question, it is only valid within the territorial jurisdiction of that particular High Court and has persuasive value elsewhere. But that is not the case when it comes to the constitutional court, because 69 is a newer penal provision and the criminal jurisprudence demands for the uniformity in its application of law, Your Lordship.
pendency of the case before two High Courts or before the Supreme Court and the High Court are conditions precedent. Otherwise, the Supreme Court cannot assume to itself the power to transfer to itself cases that are pending before the High Court.
Indeed, yes, Your Lordship. That is not being disputed by the council, Your Lordship. That is why the council stated that 139A read with 446 of BNSS. 446 of BNSS provides inherent powers to this court to transfer cases, Your Lordship.
Will it be read out 446?
Indeed, yes, Your Lordship. If the council may read, 446, power of Supreme Court to transfer cases and appeals. Whenever it is made to appear to the Supreme Court that an order under the for the ends of justice, it may direct that any particular case or appeal be transferred from one High Court to another another high court, or from a criminal court subordinate to high court to another criminal court of equal or superior jurisdiction subordinate to another high court. The Supreme Court may, under this section, only on application of Attorney General of India or of a party interested, and every such application shall be made by motion, which shall except when applicable to the Attorney General of India.
Power transfer from one high court to the other, not to itself. 446 doesn't empower the Supreme Court to transfer a pending case in a high court to itself. It can transfer a case pending in one high court to another high court.
Yes, Your Lordship. Yes, Your Lordship. That is why the Council has repeatedly stated that we have doctrinally invoked the 446 Schedule 138 because there is no express provision both in the Constitution and BNSS which says that when one case is pending before one high court, that can be inherently transferred to the Supreme Court. That is why time and time again the Council is stating that the inherent jurisdiction of this honorable court was invoked doctrinally. By the doctrine of plenary of powers, this court enjoys unlimited amount of jurisdiction. Much obliged, Your Lordship. Your Lordship, furthermore, with respect to this issue, the Council would like to wrap up by stating the doctrine of ex debito justice, which says that whenever it is needed to secure the ends of justice, a particular case can be heard by this honorable court, Your Lordship. That is because that is the paramount consideration when it comes to constitutional guarantees, Your Lordship. When constitutional guarantees such as violation of Article 21 and 14 are concerned, this court serves as the ultimate arbitrator with respect to constitutional guarantees. And this question was also reaffirmed in the case of a Supreme Court advocate on record, which may not be that paragraph number 41 of the judgment, where this honorable court has stated that it is therefore necessary to bear the distinction in mind between absence of power of jurisdiction and refusal to exercise the power. So this court inherently has power, Your Lordship. It is only with respect to the procedural prudence that this court may debate whether this petition is maintainable or not, and not with respect to the legality of the maintainability of the petition himself, Your Lordship. In argument, even if the procedural posture, because the particular petition does not meet the pre-requirements under 138, the procedural process can be debated. The inherent jurisdiction of this court cannot be seized merely because of that particular pre-requirement, Your Lordship. And the Council would like to wrap up this argument by saying that procedural stages or procedural irregularities must not override constitutional urgency, Your Lordship. Because this is a case where Article 21 and Article 14 are getting violated, and that is a very important constitutional guarantee under Part 3 of the Constitution. So when such guarantees are getting violated and a substantial question of law with such a newer provision is being
Cases under Article 14 and 21 can always be decided by the high courts also, not merely the Supreme Court.
Indeed, yes, Your Lordship. The Council completely agrees, Your Lordship. But considering the depth of this particular section, because there was no precedent section, parallel provision in IPC, where the courts can look into precedents or take other persuasive judgments to deal with the constitutional validity or redundancy. This is a very newer penal provision that was only introduced in July 2023 when BNS was introduced. So, if such a new penal provision is being decided by a high court, that will only remain within the bounds of the territorial jurisdiction of that high court as binding, and it will have persuasive value elsewhere. So, another high court can come in and say that no, I do not agree with that high court, so I will declare this provision as constitutionally valid. So, what that creates is fragmentation of law, which is opposite to the judicial uniformity principle affirmed by the Supreme Court. So, if one high court says that 69 is unconstitutional.
Maintainability is over. Your arguments on maintainability of this appeal is okay. Next point, please come to the next point.
Yes, Your Lordship. With the prior permission of the bench, the Council will be moving on to the submissions for the second issue. Your Lordship, the second issue that the Council will be dealing with is that whether the reference made by the Session Court to the High Court under Section 436 of BNSS, that is the reference to High Court, is on question of applicability and redundancy of Section 69 is legally valid, and the Council will also be dealing with redundancy of Section 69 in this particular issue, Your Lordship. Therefore, the Council will be making submissions in a twofold manner. That is, with this first submission, the Council will be dealing with respect to 437 and whether that is legally sustainable in this case. And the second part of the argument will cover whether Section 69 is redundant in light of Section before this honorable court that the reference and the order made in lieu of the reference is legally valid because of the legal sanctions under 436 and 437 of PNSS, Your Lordship. Your Lordship, the Council will be substantiating the same by giving a reading of section 436. Your Lordship, 436 of BNSS inherently deals with reference to High Court, and that is because Sessions Court is a court of trial and
there's no dispute about that. Even the other party doesn't dispute that. Okay, you can stop the argument on that next point. Yeah.
with respect to redundancy of section 69, Your Lordship. Your Lordships, with respect to redundancy of section 69, it must be noted that in this case, in the factual matrix, the accused, that is the petitioner before this honorable court, was solely charged with section 69 under the charge sheet, both under the charge sheet and the FIR. And the accused was tried only for the offence under section 69, Your Lordship. Now, Your Lordship, it is clearly mentioned in the fact that the Sessions Court, getting satisfied in light of section 63 and 28, has made a reference to the High Court with respect to validity of section 69. And the High Court has affirmed the same, declaring section 69 to be redundant. And the Sessions Court has acquitted the accused with respect to the reference order that was given by the High Court. This is legally sound and legally sustainable, Your Lordships. It must be duly noted that when the Sessions Court has any questions with respect to validity of a provision, it cannot come to a conclusion on its own because it is merely a court of trial as given in section 21 of PNSS. It is a court of trial and it can only as much do with respect to the submissions of the prosecution and defense and appreciation of evidence and cannot decide and seize on constitutional questions, and that is why this mechanism is under 436. Now, when the High Court has given such an opinion, that must be confirmably included in the final disposal of the case.
You address us about the redundancy of section 28 as well as section 69 and
Much obliged, Your Lordship.
and
Your Lord.
also the constitutional validity of section 69.
Indeed, yes, Your Lordship. The Council will be dealing in length with redundancy of section 69 and touching upon the constitutional validity, while my co-counsel will be making submissions with respect to constitutional validity, Your Lordship. Your Lordship, section 69 is not redundant in this case, Your Lordship, and that is the contention of the petitioners, Your Lordship. This is because
That's what the High Court said. The High Court said it is redundant. So you please say why it is not redundant.
Your Lordships, we are arguing for the accused, that is the petitioner, so we state that it is redundant, Your Lordship.
It is redundant. Okay.
The respondents will be talking about much obliged, Your Lordship. Your Lordship, section 69 is.
Do you mean it is redundant? Does it mean it is unconstitutional? What do you exactly mean by saying
Your Lordship,
redundant?
Council is aware that redundancy and constitutionality are two different things, Your Lordship.
Okay.
But redundancy of a provision can lead to unconstitutionality of a provision, Your Lordship. Redundancy means that a provision is inoperative or useless, Your Lordship. It does not serve the purpose which was originally intended, Your Lordship. Whereas, as opposed to constitutional validity, if it is declared as unconstitutional, that means that it is not in line with the constitutional scheme, Your Lordship. So, the Council will be dealing with redundancy.
There is an objection on the other side that these facts have taken place in 2015 and 16. The promise to marry, deceitful promise to marry was made in 2015, 10 years back, when this PSNL was not at all ego. And at that time there was Indian Penal Code, and therefore if I have committed any offence, at that time please prosecute me under the IPC, not under the PSNL. What is your answer to that?
Your Lordship, we are arguing on behalf of the accused, Your Lordship.
Okay.
We are arguing on behalf of Vicket, Your Lordship, and we are contesting before this honorable court that section 69 is redundant in light of section 63 and 28, Your Lordship. And the Council will be making submissions as to why section 69 is redundant.
That they should be prosecuted under IPC and not under PSNL.
Indeed, no, Your Lordship. That is not the contention of the Council. Indeed, yes, Your Lordship. In IPC era, if there was a sexual offence with respect to false promises or deceitful intention, it was prosecuted under section 375, read with 90. However, Your Lordship, that particular act got repealed in July 2023 and was replaced by BNS, Your Lordship. And the council will be dealing with the redundancy of section 69, and it affirms that section 69 is redundant, Your Lordship. The council will be dealing with the submission in a twofold manner. Your Lordship. Every offence requires two ingredients, Your Lordship, mens rea and actus rea, Your Lordship. The contention of the council is that section 63 read with section 28 eclipses the operation of section 69, Your Lordship. That is because, Your Lordship, the actus rea under section 69 and 63 is sexual intercourse with a woman, which is same. And furthermore, Your Lordship, when we talk about the mens rea under section 63 and 69, it gets eclipsed, Your Lordship. There is ambiguity in the provision of section 69, Your Lordship. Because of the vagueness of the provision, there it inherently is redundant, Your Lordship. Your Lordship, the council will be making submissions on behalf with respect to State of West Bengal versus Anwar Ali. In paragraph number 7 of the judgment, it was given that for a provision to be manifestly arbitrary, it must fail the test of intelligible differentia and racial nexus with the object, Your Lordship. And that is the case in this particular with respect to this particular section, Your Lordship. Because, Your Lordship, under the doctrine of strict construction of penal statutes, it is a well-known fact that in case of any ambiguity, that should not prejudice the accused. In fact, it should favor the accused. In this particular section 69, there is vagueness because it fails to distinguish the mens rea, which differs from section 63, Your Lordship. And when such an ambiguity is there in this particular penal provision, the accused enjoys the presumption of innocence, Your Lordship. And that is the criminal jurisprudence that has been put forth by this Honorable Court, Your Lordship. Your Lordship, citing the case of Pramod Surya Ban Pawar versus State of Maharashtra, where in the pre-BNS era, under 375 read with 90, it was held that false promise with the intention of being broken later on amounts to rape. So the court before has said that when a sexual intercourse is committed with a deceitful intention, it amounts to rape. Now, the section 69 disputes that, stating that no, it does not amount to rape. So this creates judicial ambiguity, Your Lordship. Because then again, Your Lordship, it fails the test of intelligible differentia and racial nexus under Article 14 of the Constitution, Your Lordship. Because it is inherently vague and ambiguous, and it also fails under the doctrine of strict construction of penal statutes, where it is a well-known fact that if it is a penal statute, it must be strictly constructed with no legal ambiguity.
69 is unconstitutional according to you.
Indeed, yes, Your Lordship. That submission in length will be dealt by my co-counsel. Your Lordship, furthermore, if we see with respect to the pre-BNS era, where 375 and section 90 was concurrently used to prosecute the accused who have committed sexual intercourse with the deceitful means, as seen in landmark judgments such as Uday was the state of Karnataka and Deepak Gulati was the state of Haryana. It was held by the court that such criminal offences, that is sexual intercourse with deceitful means, was prosecuted under this provision of rape in pre-BNS era. That again creates judicial ambiguity because when a particular offence has been dealt in a different manner by the courts before the introduction of the section, and now this particular section says that it does not amount to rape. But however, only that distinction is made between section 63 and 69, but not with respect to the mens rea of the accused under 63 and 69. And that is the submission of the counsel, Your Lordship. Your Lordship, furthermore, moving on, Your Lordship, it may be contended that section 69 is a special provision as opposed to section 63, which is a general provision. However, Your Lordship, it is time and time again held by this Honorable Court, as seen in the case of Union of India versus GM Kokil, where it was held that if it is a clause 2, Your Lordship. In case such an ambiguity leads to the same person being convicted or tried under both the offences. And furthermore, Your Lordship, it must be duly noted that 63 has a higher punishment compared to 69, which has a lower punishment. 63, which punishment is given in section 64 of BNS, says that 10 years of imprisonment which may go prolonged till life imprisonment. However, section 69 states that the entire punishment period is only limited to 10 years. Now, this again creates a judicial ambiguity, Your Lordship, because previously when accused were tried for under 375 and 90, they were convicted for longer periods as opposed to 69, Your Lordship. So this, in light of all these submissions, the council says that section 69 is inherently redundant because it is vague and ambiguous and it does not pass the test under the 6th construction of penal statutes, Your Lordships. Your Lordships, if you are satisfied with this issue in hand, the council seeks permission to move on with the submissions for now.
You are not satisfied with your concept of redundancy or inoperable. When Parliament has very specifically created a new offence stating that any deceitful promise to a woman to marry and having subsequent sexual intercourse amounts to an offence, a separate offence. Where is the redundancy in that? How can you say it is inoperable?
Your Lordship,
You may argue that it is discriminatory, it only punishes men and not the women, etc. But how can you argue that it is redundant? Redundant doesn't mean we should read it out of this act itself. It is not operative, it's not at all enacted, as if not acted by Parliament, or what do you exactly mean by saying it is redundant?
Your Lordship, it is the humble contention of the petitioners that section 69 is inherently vague, Your Lordship. While it states the offence and what might be considered as an offence, it fails to distinguish the mens rea factor in section 69, Your Lordship. However, Your Lordship, if we take section 63, which is rape, the definition of rape in itself is given in 63 and the offence is the punishment for the offence is later dealt in 64. Where in 63 the mens rea is distinguished, the actus rea is distinguished. But in section 69 that is not the case. It is merely given that when sexual intercourse is done by deceitful means, that will lead to an offence, Your Lordship.
Parliament made it a lesser distinct offence. It's a lesser offence, a distinct offence. Not rape. Rape is a different offence. And promising to marry and then having intercourse is also a lesser offence, but a distinct offence. That is what, so you can't say that it is redundant or what inoperative or something. Okay, whatever. Proceed.
Sir, much apologies, Your Lordships. Your Lordships, but the contention of the council is that the mental threshold, both under section 63 and 69, is similar, Your Lordships, and it is vague. And that.
Yeah. You need not repeat that.
And section 69 is merely a relabeled version of section 375 of IPC read with 90, that is section 63 read with 28, Your Lordships. So if the courts read section 63 and 28, it gives the same outcome as section 69. Therefore, there is an internal conflict within the same statute, Your Lordships, which again fails the test of reasonable classification under Article 14, Your Lordships. Your Lordships, considering the time constraint, the council will be quickly wrapping up issue 3 in this 2 minutes, Your Lordships. Your Lordships, the third issue in hand that the council will be dealing with is with respect to the acquittal of the accused under section 437 and whether it is legally sustainable in law, Your Lordships. Your Lordships, it is the contention of the council on behalf of the petitioners that the acquittal under the section 437 of BNSS is legally sustainable, and the council will be dealing with this submission in a twofold manner, which is that acquittal is in strict compliance with the legal sanction under section 437 of BNSS, and the second sub-argument that the council will be placing is that there is no procedural irregularity or miscarriage of justice that happened during the trial, Your Lordship. The Lordship 437 mandates that when a superior court, that is High Court in this case, has given a legal opinion or a legal question of law, these subordinate courts are expected to follow the same when they are disposing the case, and that was correctly done by the Sessions Court in this case, Your Lordship. And it must be noted that in this factual matrix, victim is only tried for the offence under Section 69. So the maintainability.
Why the appeal came now?
Your Lordship, with respect to the same, if we refer to Section 511 of BNSS, it states that under subclause 2 that if the parties, either of the parties are of opinion that during the trial there was a miscarriage of justice, they can raise objections during the trial. But that was not done by the respondent in this case, Your Lordship. They did not raise any objections with respect to miscarriage of justice, Your Lordship. In the entire factual matrix, there is no statement which proves that advocate has made an objection before the Sessions Court with respect to the miscarriage of justice that has occurred, because there was no miscarriage of justice that has occurred, Your Lordship. The Sessions Court, bound by its legal sanctions under 436 and 437, has acted correctly in law and has confirmed with the High Court's opinion and has acquitted the accused, Your Lordship, which is legally sound and legally sustainable in law, Your Lordship. Your Lordship, the Council would like to state the case of State of Punjab versus Davinder Singh, which is given in the class number 4 of the petition complaint, where the Supreme Court opined that when a trial court follows the procedure that is given under the statute, it cannot be vitiated merely because it had an alternate course of adjudication. In this case, the respondents cannot state that the trial could have happened in a different manner, because this Sessions Court has acted in conformity with the legal sanctions under PNSS. So it cannot be said that the Sessions Court did not apply its mind when rendering the acquittal of the accused, Your Lordship. And this is the humble submission on behalf of the petitioners, Your Lordship. Furthermore, Your Lordship, once an accused is acquitted, he enjoys double presumption of innocence. Presumption of innocence exists when before the guilt of an accused is proved before a trial court. And once the accused is acquitted, he enjoys double presumption of innocence. Once before he was rendered guilty, and twice because he was acquitted because he did not commit any offence. And in this case, the petitioner clearly enjoys the double presumption of innocence before this honorable court, Your Lordship. With that, the council will be wrapping up the argument. Any questions on behalf? Much would like to. The council seeks permission to approach the court. The council seeks permission to move on with issue 5 in hand and then proceed with issues 4 and 6, Your Lordship. Much obliged, Your Lordship. Your Lordship, issue 5 deals with whether Section 69 of BNS 2023 is constitutionally valid in light of Articles 14 and 21 of the Constitution of India. Your Lordship, the humble submission is that this particular issue concerns about the constitutional validity of Section 69 of BNS. And the petition humbly submits that this particular provision fails to align with the guarantees of Article 14 and Article 21 of the Constitution, because primarily, Your Lordship, Section 69 criminalizes the failure of a personal relationship merely on the basis of a promise to marry, and it does not insist upon any proof that such promise was deceptive right from the inception of the relationship, Your Lordship. And by doing so, what the provision does is that it converts the outcome of a relationship, the way a relationship is broken, it converts it into a penal consequence, and thus, with respect to that issue, it is constitutionally impermissible, Your Lordship. And it must be duly noted that the foundation of criminal law, that is, criminal law proceeds on culpable intent, which is the mens rea. But Your Lordship, Section 69 completely departs from this foundational principle of criminal law, Your Lordship. Because Section 69 has already mentioned, it does not require the prosecution to establish any kind of proof that the accused never intended to marry right from the inception of the relationship. So that is the primary issue of Section 69, Your Lordship. And what happens is,
try to justify the constitutional validity of Section 69 under Article 14 of the Constitution. Whether the classification made that men are punishable if they make a false promise to marry and have sexual intercourse, but later on they revoke it. But women
they are not
can make
punished.
similar promise and can have sexual intercourse, and still women, if they don't marry, they are not committing any offense.
In Yes, Your Lordship.
Is this classification reasonable?
Indeed,
And
no, Your
what
Lordship.
is the object sought to be achieved?
Indeed, Your Lordship, this particular classification is not reasonable, and that is the very contention of the council, Your Lordship, because we are contesting that our section 69 is unconstitutional, Your Lordship.
Okay.
Yes, sir. Your Lordship, with respect to this, in the landmark judgment of Sayara College as a Union of India, it was made very clear that whenever a provision lacks proper determination criteria, when it does not mention any adequate determination criteria, whenever a provision is irrational, disproportionate or capricious, in that situation it falls under the ambit of manifest arbitrariness. And section 68 exactly falls under the concept of manifest arbitrariness, because, Your Lordship, as mentioned and as required under Article 14, it does not satisfy the twin test, which was established in the case of E.P. Rayappa v. State of Tamil Nadu and many other cases, whereby there is no intelligible differential between the classification made. The primary classification, that is primary discrimination or distinction that is made under section 69 is that it only provides for women, as Your Lordship rightly noted. It only provides for women, whereby when women get cheated by a deceptive promise to marry, then men are getting punished. But in the same situation, when men are put under the same situation, when men are suffering under the same situation, then no such punishment is provided for women. So this itself is fighting at the heart of Article 14, whereby equality is not pertained in this particular section, Your Lordship. Moreover, considering this situation, section 69.
15.1. What is 15.1? Article 15.1.
15 plus 1, Your Lordship.
Article 15.1.
It provides that whenever a law is made favoring a vulnerable group of people,
State shall not discriminate. 15.1.
Indeed, yes, Your Lordship, but 15 clause 2 provides for the provides
State shall not discriminate on the basis of race, religion, caste, sex, place of birth, or any of them.
But that is the exact discrimination that has happened in section 69, Your Lordship.
Yeah.
Although section 15 clause 2, article 15 clause 2 provides for women, but at the same time, as Your Lordship rightly noted, 15 clause 1 states that the state shall not discriminate, but section 69 exactly does the same, because it only provides for one community of people. Also, Your Lordship, in this situation, what section 69 does is that it does not provide for, it does not define the concept of deception, it does not define the concept of false promise to marry, and it does not define the mens rea clearly. There is a lot of ambiguity in section 69, and to what situation this will lead to is, there might be two distinct situations, whereby one particular relationship is broken on a genuine basis. There might be a mutual breakdown of trust or a genuine change of belief. So the relationship might be broken for genuine reasons. On the other hand, as this offense clarifies, the relationship might be broken because of deceptive intent right from the inception.
Council, fact says that deception from inception itself. The fact says that deception from inception itself.
Indeed, no, Your Lordship. According to the fact, there is no deception right from the inception of the relationship, Your Lordship.
Inception.
It's a question of fact. Whether there is deception right from inception or not.
In this particular factual matrix, there is
Promise
no...
to marry is there.
Your Lordship.
Promise to marry is there.
Promise to marry is there, Your Lordship, but as held in the case of, even prior to the enactment of BNS, during the IPC regime itself, it was held in the case of Uday as a state of Karnataka and D. Pakulati as a state of Gujarat, that the primary element with respect to deciding in this type of case is that the primary element or primary criteria is that there must be deception right from the inception of the
You are
relationship.
speaking about change of substances, that you want to be celibacy. That is the furthermore. But at the inception itself, we want to marry. That then fact itself discloses that deception since inception.
Your Lordship, during the inception of the relationship, he wanted to marry. But the element is that the person who promises to marry must have a deceptive intent. That is right from the inception of the...
How to actually find out whether this deceitful consent is given right from the beginning or not?
Indeed, yes, Your Lordship. That is a very problem in section 69, Your Lordship.
Just quoting. Even the devil knoweth not the man's mind. That is, in English there is a proverb. Even the devil knoweth not the man's mind.
Indeed, yes. In that situation, Your Lordship,
With what intention he actually promised to marry, it's very difficult to find out.
Your Lordship, when we consider about evidence or when a case is tried to be proved, Section 6 of BSA states that prior conduct and subsequent conduct will be considered and it has relevancy to the factual issue.
How do you argue now on Article 21? How does it violate Article 21 of the law?
Your Lordship, Section 69 directly violates Article 21, Your Lordship, because as you know, in the landmark judgment of case Puttaswamy versus Union of India, it was held that each and every person has their own autonomy and their own right to choose their partner, which also includes right to not marry. So in this situation, Article 21 clearly provides for all these rights.
The law is not forcing you to
marry. In that situation, it will lead to coercion to marry, Your Lordship. So that is the primary.
You mean to say you can give a promise that you would marry somebody, have sexual intercourse, and then after some time say bye-bye, there's nothing wrong with it?
Indeed, no, Your Lordship. That is why the council is repeatedly contending that there must be a properly set out guidelines or a properly set out definition whereby we must be able to prove that the person is refusing to marry because it was not his intention right from the inception itself. So in order, if at all we are able to prove that situation,
What a genuine love.
That there is a promise to marry with some fraudulent intent is assumed, and then he refused to marry is assumed, and then a crime was registered. When the case has come up before the court, he agreed to marry and gets married. What happens to it then?
he agrees to marry after the case, Your Lordship.
This case was lodged before the court, and before the court actually takes it up. He consented for marriage, he was very happy, everybody was happy, they got married. Then would it actually efface the offense that is alleged, or it still survives?
Your Lordship,
Still be prosecuted.
again, Your Lordship, the situation is that in this particular situation, what?
No, we are only just, this is not mere hypothetical, we are only trying to assist you in looking at the constitutionality or otherwise of the provision.
Indeed, yes, Your Lordship.
Only that way we are only asking.
Indeed, yes, Your Lordship. As slightly noted, Your Lordship, all these ambiguities are already present, and Your Lordship, in such a situation, what you have to depend upon is the intent or the density of the person, Your Lordship. If at all he is agreeing to marry again,
You are supporting that it is unconstitutional.
indeed, yes, Your Lordship.
Then what are the
Confer dysregulated or unregulated power on courts. So what will happen is regulated power on courts. So what will happen is since the provision does not define all the requisites properly, each court will interpret this particular section in different manner, and that will again lead to fragmentation and it will violate the principle of judicial uniformity, Your Lordship. So only when a particular provision, because criminal law is confined to the concept of strict interpretation. So we can only interpret a particular provision within the four walls of the textual ambit, Your Lordship. In that situation, since there is no proper definition or proper mens rea that is being provided, in that situation, using strict interpretation, if a court is interpreting this particular provision, and each court will interpret it in a different way, again it will lead to fragmentation, Your Lordship, and that is again it leads to a vagueness of this provision, Your Lordship. And these are all the grounds on which the council contends that this particular provision is unconstitutional. And also, Your Lordship, in the landmark judgment of S.Chandra, which is
You mean to say that right to belong to a particular religion gives him a defense not to marry, because I first promised to marry. Now I don't believe in any religion, I want to be a celibate, therefore I don't want to marry. Article 25 confers that right on you, either to belong to a particular religion or not to belong to any religion. So does it confer any defense on him to say, I promised to marry, but now I am a celibate, so I don't want to marry?
Your Lordship,
25 gives me that fundamental right.
Your Lordship, when they are into a relationship, apart from the fact that, apart from the situation where his intention was deceptive from the inception, apart from that, in all other circumstances, through the phase of relationship, any kind might happen to a particular person. A relationship will not define that. So there might be a genuine change of his belief, your lordship, and if at all this concept is considered, then the concept of divorce will also not be there, because only because people's character or people's beliefs change, the breakdown of relationship is happening, your lordship. In that situation, if at all there is no malevolent intention, if there is a genuine intention, then he is rightly using this right under Article 25, your lordship. If your lordship is satisfied with the arguments of issue 5, the council seeks permission to go on an issue.
Instead of Article 25, he decided to remain celibate. That is, in fact, on facts it is redundant, because he already had a relationship with one woman. The question of celibacy doesn't happen. From there onwards at least. After the fact. So, can you explain? The first ingredient of 69 is no intention to marry. The second ingredient is promise to marry. Third ingredient is, under that conception, he will have intercourse with that woman. Now, in this case, he lived with her, they wanted to marry. Of course, the facts do not say that there was promise, they just both agreed to marry. And then this celibacy, can you explain that stand taken by the accused, that he wanted to now suddenly remain celibate? Is it not related to the initial ingredient of he has no interest of marrying at all? Both are related. He stand now, then go back to that initial promise to marry without any intention to marry.
Your lordship.
Sorry, can you explain it you can?
Yes, your lordship. Yes, your lordship. To defend the same, your lordship, it must be duly noted that in the same factual matrix, it is very clear that both of them, that is Arjati and Vikyat, are into a decade-long relationship. They started the relationship right from 2015-16 and until 2025 they are into a relationship. So it's a long consensual relationship, and it must be duly noted that they decided to settle in law practice together, and very importantly, they jointly purchased the house and they started to live in, and also both their families are well informed about the situation. They are well informed about the relationship between Aditi and Vikyat. And also the society is also very well informed, because the factual matters very clearly mentions that they started living like husband and wife. So all these factors clearly mentions that, clearly proves that Vikyat did not have any disciplinary intent right from the beginning of the relationship, and it is also clearly mentioned that only from 2025 he started to avoid Aditi. Yes, your lordship, with your permission, may move on with issue 4, your lordship. Much appreciated. Your lordship, issue 4 deals with whether the in-plea petition filed by Women Power NGO is maintainable and to what extent it may question the constitutionality of a penal provision in a case like this. So, your lordship, the humble submission is that the in-plea petition filed by Women Power NGO is not merely procedural. The primary contention is that the in-plea petition is not maintainable, your lordship, because this particular in-plea petition does not come under the inherent judicial power, and rather it is just the creation of the statute, because, your lordship, only under Order 1 and Order 1 Rule 10 of CPC there is a provision for in-plea petition, but CPC does not operate in abstract equity, rather it only operates in defined jurisdictional ambit. In that situation, even the Order 1 Rule 10 cannot be applied analogously, and also, even if it is applied doctrinally or analogously, it must be duly noted that Section 3 of CPC, when defining code, it defines that the code includes only until the jurisdiction of High Court. So the High Court has accepted the in-plea petition, but it does not involve the inherent jurisdiction of the Supreme Court, your lordship. Therefore, the concept of in-plea petition under Order 1 Rule 10 of CPC cannot be inherently invoked in this particular case. Also, your lordship, with respect to even assuming an argument that CPC principles may be borrowed analogically, this court in the case of PV National Law versus State has repeatedly, and also in other cases has repeatedly held that borrowing of principles is strictly limited and it cannot alter the nature, scope or adversarial structure of criminal proceedings, Your Lordship. And with respect to that, the Council would also like to state the case of A.R. Antule versus R.S. Nayak, whereby this Honorable Court has issued a categorical warning, which is criminal procedure cannot be expanded by judicial innovation, whereby particularly in a situation where such expansion prejudicial the accused or bypasses the legislative design, Your Lordship. And also, when allowing this impeach petition, the right of the accused is negotiated and negated, Your Lordship, because it again strikes at Article 14 and also the doctrine of equality of arms. Because the women power NGO is only in support of Adviti and it is contending for the constitutionality of Section 69, whereby Vikyat, that is our client, is representing only by himself. In this situation, when a particular impeach petition is allowed to represent one particular party or to support one particular party, it again strikes at Article 14, Your Lordship. And also, even in the CPC jurisprudence itself, the concept of impeachment is confined to necessary or proper parties. In the case of Kasturi versus William Perumal and others, it was said the two-test concept to determine whether a party is a necessary party or not was held, Your Lordship. And in that situation, and also in the
Who thought that somebody else could actually help it? He thought that you are a better counsel. It could elicit your advice. The court holds such a power. On the other side of the same thing, when you volunteer saying, yes sir, I am prepared to advise you, there is a question of anybody is a party. You are only an advisor. See, either I ask for the so much, or you volunteer and accept for it. You are not a party in the strict sense of the you didn't get criminal. You are not giving any form of advice. The third party has no pleasure or pain in the outcome of the judgment when an accused is either acquitted or convicted. So, the voluntary organization or whichever it is, which seeks that it wants to actually submit some arguments for the Supreme Court. And Article 136 as an Lordship put forward.
Your Lordship, if at all in argument.
First example is West Bakery's case and Gujarat Rights case.
Your Lordship, if at all the impeach petition is allowed, again, as already contended, it may advise on the constitutional discussion which is being held in the Honorable Court, Your Lordship. But it is clearly mentioned that this women power NGO is supporting one particular side. But there is no particular person to contend on the other side, Your Lordship, and that will violate Article 14, Your Lordship. And also, Your Lordship, if at all the court wants to take any assistance, Your Lordship, the court has the power to appoint an amicus curiae, Your Lordship. So that can be done. If Your Lordship is satisfied with the arguments of issue 4, may I move with issue 6? Much obliged, Your Lordship. Issue 6 in hand deals with whether Vikyat is liable to be convicted under Section 69 of BNS in light of the facts and circumstances of the present case, Your Lordship. With respect to that, the humble submission is that Vikyat is not liable to be convicted under Section 69 of the BNS because the foundational requirement is, as already mentioned by the Council, the foundational requirement is fraudulent intent at inception, and it is wholly absent in this particular case, Your Lordship, because in the landmark judgment of, with respect to this particular case, in the landmark judgment of Uday versus State of Karnataka, it was held that a breach of promise to marry cannot be itself constitute an offence unless the promise was never intended to be fulfilled at the time it was made, and this principle was also reiterated in the case of Pramod Suryaban Power versus State of Maharashtra, Your Lordship. And in this situation, the legal character of promise to marry is contended here, Your Lordship, and where the court has clarified that the intention at the inception is itself is the decisive test of the determination criteria, and subsequent changes in the personal choice cannot be retrospectively criminalized with respect to the prior consensual conduct, Your Lordship. And by applying this particular doctrine to this present case, the long-term consensual relationship between Adviti and Vikyat, whereby knowledge and involvement of families and joint purchase of property as already considered, conclusively negate that there is no interference of deception at inception, Your Lordship. And also considering the legal character of a promise to marry, in the factual matters it is mentioned that both of the parties agreed to marry or they got into an agreement to marry. But it must be duly noted that
Do you concede that there is a civil wrong committed by that man?
indeed no, Your Lordship. Because
He can be sued
No, he cannot be sued because as under the contract, Indian Contract Act and also under the land of judgment which has been referred to Indian court, Balkar versus Balkar, it was very clearly mentioned that social contracts or personal contract, personal contract.
You cannot sue a person for breach of contract.
We can sue a person for breach of contract here also, but personal agreements without consideration as mandated under section 23 will not be an enforceable.
Criminal case, I'm talking about civil law.
In civil law, a valid contract under the Indian Contract Act can be, if it was entered into, then you can sue the person who breached the contract. But your lordship, a social contract or a promise to marry is not an enforceable contract as it is void under the Indian Contract Act as mentioned under, as held under the land of judgment of Balkar versus Balkar and also under section 23 and section 73. Yes, your lordship. Moving on, your lordship, indeed, yes, your lordship. Moving on, your lordship, the criminalizing a breach of such a personal promise will also offend the public policy, your lordship, because as already mentioned under section 23 of Contract Act, it is mentioned that agreements whose enforcement defeats the provision of law and public policy are void. And also, your lordship, in the land of judgment of Joseph Change in the Union of India, it was categorically held that the state cannot use criminal law to enforce private morality. And your lordship, even in the case, assuming in our view that section 69 is constitutionally valid, in this present factual matrix, the essential ingredients are not satisfied in the present case, your lordship, because in the case of Maheshwar Tika versus State of Jharkhand, the Supreme Court held that prolonged consensual relationships and conduct reflecting commitment are inconsistent with the allegations of false promise. And also in the case of Tilak Raj versus State of Himachal Pradesh, the court cautioned against converting failed relationships into criminal prosecution. Therefore, in this present case, wicked conduct marked by openness, duration and mutual planning falls squarely outside the mischief that is sought to be addressed by section 69, your lordship. And also, as previously conducted, it also does not satisfy section 6 of BSA, your lordship, which considers about prior and subsequent conduct. So this is the submissions of issue 6. Therefore, it is humbly submitted that wicked is not liable to be convicted under section 69 as far as the present factual matters is concerned, your lordship. If the lordship is satisfied with the argument, we also seek permission to move on with the prayer. Wherefore, in the light of the issues raised, arguments advanced and authority cited, it is humbly requested that this honourable court may be pleased to adjust and declare that the acquittal of the petitioner as recorded by the Court of Session shall be upheld, and section 69 of the Bharati Nyaya Samhita 2023 is unconstitutional and redundant and not any other order, direction or relief, having been deemed in the interest of justice, fairness, equity and good consent. For this understanding, the petitioner has to duty bonds in follow-up.
You don't want us to declare the article as unconstitutional.
That is also a part of the prayer, lordship.
You didn't mention that.
The council mentioned that, your lordship. Yes, your lordship. Much obliged, your lordship.
Your lordship, the council seeks permission to offer strike. Much obliged.
ఈ పేపర్ దొరికి సౌండ్ వచ్చింది టెస్ట్ పించి వచ్చింది తగలకుండా చేసుకో పేపర్స్ ఈ పేపర్స్ తిప్పినప్పుడు దానికి తగలకుండా చేసుకో
Your Lordship, the Council seeks permission to collectively address the bench as Your Lords. Much obliged, Your Lordship. Your Lordship, the Council appearing on behalf of the Respondent Vikyat in the matter of Adviti versus Vikyat and the State of Andhra Pradesh and Women Power NGO as intervener, which is a matter transferred before this Honorable Supreme Court of India. Your Lords, I want to make one thing clear before this bench, which is a grave error committed by our friend counsel before starting my submissions. Lord, Vikyat is the petitioner of the transfer petition filed under Article 139A Class 1. But the is also the respondent of the criminal appeal that has been transferred to this Honorable Court, Your Lords. Now, the criminal appeal made by the Adviti under section 413 of BNS is now just transferred to this honorable court, your lords, and listed for adjudication before this honorable court. It is clear as per the facts. The appellant, the Adviti just appealed against the order of the acquittal provided by the section court. The provision for appeal by the victim is given under section 413 of BNSS, your lords. As per, she appealed to the Honorable High Court, and while the appeal is pending, as per the facts, while the appeal is pending, this matter is just transferred to this honorable court under Article 139A Class 1, which is the absolute provision to invoke the jurisdiction and the to submit the arguments on the particular matter, your lords. If your lords are well versed with the facts, the council seek permission to move on to jurisdiction. The appropriate jurisdiction for this transfer petition is filed by the Vikyat before the Honorable Supreme Court under Article 139A Class 1, read with Order 40 Supreme Court rules. Honorable Supreme Court is as jurisdiction to entertain the same. The respondent Vikyat responding to the criminal appeal filed by the appellant under section 413 of BNSS in the Honorable High Court of Andhra Pradesh. Also, the Women Power NGO, who is impleaded as an intervener under section 528 of the BNSS, and Vikyat is responding to this. And the state of Andhra Pradesh is arrayed as pro forma respondent, supporting the case of appellant. Since the appeal is against the order of acquittal, the state of Andhra Pradesh is arrayed as a pro forma respondent, your lords. Your lords, with your permission, may I move on to the first issue? Much obliged. Your lords, the first issue arise for the adjudication is whether the transfer petition filed by the Vikyat seeking transfer of the appeal to this honorable court is maintainable or not. Your lords, the council most humbly submit before this honorable court the first issue, before this Honorable Supreme Court of India, the transfer petition filed by the Vikyat under Article 139A Class 1 is absolutely maintainable, your lords. These articles enables the High Court, your lords, Honorable Supreme Court to withdraw any cases pending before High Court to this court on prescribed condition and adjudicate thereof, your lords. Firstly, the respondent Vikyat has clear locus standi to file the transfer petition under Article 139A Class 1. Lords, with your permission, may I read the provision of the Article 139A? It is a clear prescribed condition. The jurisdiction under Article 139A Class 1 can be exercised by suo motu or any application made by Attorney General or made by any party to such case. And also it should be pending before 2 or more high courts or before Supreme Court and 1 or more high courts.
Is mentioned in the fact that the matter is pending in another high court. But cannot be like that. The new fact which is not there in the fact, the fact says this is the only case pending before this Andhra Pradesh High Court, not Kerala High Court. We didn't say that.
Lords, as per the current affairs, just for information, it is submitted for the reference before this honorable court.
Before Kerala High Court, it's perfectly valid.
Much obliged, your lords. Here, the Vikyat as the primary respondent to the appeal clearly qualifies the term any party to such case prescribed under Article 139A Class 1. Hence, the locus of the respondent is clearly proved here, and the first essential is satisfied here, your lords. Secondly, as highlighted by Honorable Justice Aniruddha Bose in Sunil Rathi versus State of Haryana 2020, which is in page 8 and 9 of the compendium, your lords might kindly take it supportive. There shall be same or substantially same question of law which is of general importance should be present in the case, your lords. Here, the case involves constitutional interpretation of section 69 of BNS, which is a new provision enacted by the central legislation. The constitutionality is challenged as the provision is arbitrary, discriminatory and implicit gender stereotypes, your lords. Also, the punishment which is given under article, pardon your lordship, which is given under section 69 of BNS seems to only intended for the male offenders, but there is no any implied or express term which includes the female offenders also, your lords. This forms a compelling reason which is necessitated by this honorable court in Menaka Sanjay Gandhi versus Rani Jethmalani 1979, which is in page 6 of the compendium. Your lords kindly refer, which is the essential component to invoke the transfer jurisdiction under article 139A class 1. Next, it is submitted before this honorable court without any proper interpretation and settled principle in context of section 69 of BNS. It is being misused against innocent men like the respondent, as necessitated by this honorable court in Sir Chunilal Mehta and Sons versus Century Spinning Manufacturing Company Limited 1962, which is in page 4 of the compendium, your lords. It was held a substantial question is of general public importance, or if it directly and substantially affect the right of the parties, or it should be either open, unsettled, or calls for discussion of alternative views. Here, the substantial question in the present case are open, unsettled, and requires an authoritative interpretation and binding precedent, your lords. Your lords, to conclude, this honorable court in Abdul Nasir Madani versus State of Tamil Nadu 2000, which is in page 12 of the compendium, my lords kindly refer. It was held that no rigid rules govern transfer petition and which is governed by the facts of each case, your lords. It is point to be noted, this transfer petition is clearly allowed by this honorable court after thorough analysis of the facts and circumstances of the case, and claiming it as not maintainable undermines the valuable decision of this honorable court, your lords. Hence, it is therefore prayed before this honorable court, the transfer petition is absolutely not maintainable under article 139A and deserves to be stand alone. If your lords are satisfied with my arguments on first issue, shall I move on to the next?
Yes.
Much obliged. The second issue for adjudication is whether the appeal against the acquittal preferred by Adviti before the High Court is maintainable or not. Your lords, it is humbly submitted before this honorable court. The appeal filed by the Adviti under section 413 of BNSS is absolutely not maintainable. The appeal mainly non-maintainable on two grounds, your lords.
You are appealing for? No. Who is your client? Your client is?
Our client is Vikyat, your lords.
Your client? Yes, please. Please go on. Two crowds you are
Yes, your lord. Mainly non-maintainable on two grounds, your lords. Firstly, the appellant Adviti failed to seek the leave of High Court for leave of the High Court, which is mandatory for the criminal appellate process. Here, the mandatory leave of High Court is not obtained, your lords, which is mandated by this honorable court in Satyapal Singh versus State of Madhya Pradesh 2017, which is in page 16 of the compendium, your lords. Further, in State of Rajasthan versus Sohalal and others, which is in page 14 of the compendium, the court highlighted the importance of seeking leave for appeal, which is that provision for seeking leave to appeal is to ensure that no frivolous appeals are filed against the order of acquittal, your lords. It was reaffirmed in Mallikarjuna Kodagali versus State of Karnataka 2018, which is in page 18 of the compendium, which clearly mandates seeking leave for appeal under section 378 class 3 of CRPC, which is now 419 class 3 of BNSS. It is clear a preliminary hearing for deciding the grant of leave ensures that the matter of appeal is worth looking or just filed as frivolous. Here, hence it is clearly get to know that the appeal filed by the appellant Adviti is only to waste the valuable time of this honorable court and against a clear order which acquitted the accused, the respondent Vikyat, your lords. Thus, this appeal is not maintainable and has to be dismissed on this ground. Secondly, section 69 of BNS is held redundant and inoperative by the order of High Court under section 437 of BNSS, and based on that, the accused is acquitted and the case is also dismissed, your lords.
Explain us the concept of any section redundant. How a section in a particular act enacted by Parliament can be inoperative or redundant? What does this actually mean?
The redundancy of a provision amounts to unconstitutional.
Yes, Your Lords. It's what we are.
Find the legal holding for it.
Yes, Your Lords. That's why I was saying submitting before this honorable court.
69 is unconstitutional.
Yes, Your Lord.
Along with them, we also agree that
Section 69 is unconstitutional, which is arbitrary. An inoperative provision cannot form the basis of an appeal, Your Lords. Hence,
he is going to argue about the
constitutional validity, the redundancy, and the criminality of Section 69. Yes, Your Lords, that's the reason the state also not choose to appeal, since it's an inoperative provision, Your Lords. Thus, this appeal is to be dismissed on this ground too. Your Lords, therefore, it is prayed before this honorable court. The appeal has to be held not maintainable and dismiss it accordingly, Your Lords. If Your Lords satisfied with my arguments on second issue, shall I move on to the next? Much obliged, Your Lords. The third issue for adjudication is whether the implement application filed by the Women Power, a voluntary organization, in the appeal is maintainable or not. Your Lords, the Council humbly submit before this honorable court the implement sought by the Women Power organization in the appeal is not maintainable. First of all, the absence of locus standi. It is clear settled principle that the criminal appeals typically remains between the accused, victim, and the state, Your Lords. Also, the criminal law treats offence as a wrong against state. This honorable court in Thakur Ram vs. State of Bihar 1966, which is in page 22 of Compendium, my Lords kindly refer. In criminal matters, the aggrieved party is the state, which is the custodian of social interests of the community at large, and the appellants fail to provide any precedent where NGO is allowed to implead in criminal matters, Your Lords. Your Lords, from this it is very clear the parties to this present case also is the state, victim, and the appellant, and the third party intervention is against the procedures of law, Your Lords. In P.V. Narasimha Rao vs. State 1997, which is in page 24 of the Compendium, it was highlighted by this honorable court that unlike Order 1, Rule 10 of CPC, there are no such concept of impleadment in criminal matters. It was clarified by this honorable court. Also, it is humbly submitted before this honorable court. The third party intervention prejudices the fairness of the criminal appeal. If the Women Power organization really wants to check the constitutional validity, they may invoke the jurisdiction under writ jurisdiction of this honorable court under Article 32, and even they can invoke in under Section 226 of the Constitution, Your Lords. This honorable court have consistently relaxed the strict interpretation of locus standi.
Go through Article 136. Article 136. Refer.
Special leave to appeal by the Supreme Court.
136 of the Constitution. Special leave to appeal.
Yeah, indeed, Your Lords.
136 of Constitution.
Special leave to appeal by the Supreme Court, 136 of the Constitution. Notwithstanding anything in this chapter, the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. Nothing in clause 1 shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to armed forces.
So it's not under 142, it has jurisdiction under 136. That's what Judge says. Yeah.
How Supreme Court entertained an application best backers?
No, Lords, the impleadment of a third party cannot be either allowed.
Not impleadment, intervention.
Intervention.
Intervention is different from impleadment.
Lords, the impleadment application filed for the intervention of the parties and vulnerable sections, but the relaxation is mainly intended to strengthen the public interest litigations, Your Lords, under Article 32 and 226 of Constitution, but not.
My lords, this is the second counsel appearing on behalf of the respondents, and I would be dealing with the fourth, fifth and sixth issues, my lords. My lords, I seek permission before this bench to clarify this bench what my co-counsel have intended to say for maintainability of transfer petition. Much obliged, my lords. My lords, to maintain a transfer petition under Article 139A Class 1, there are two important components that needs to be satisfied. The main important component is that case with the same or substantially same question of law must be pending before the Supreme Court and one or more High Court, or between two or more High Courts. My lords, what my co-counsel intend to say is, as per the fact given, it is stated that the case is only pending before High Court of Andhra Pradesh. We agree with that, my lord. But as section 69 is a newly enacted provision, there might be a chance of parallel challenges against the same provision. Your lordship, to support this claim only, we have mentioned about the Vimal Vijay versus State of Kerala case. In that case, when the case was pending, as per the facts given in the Moot proposition, the case has been transferred to Supreme Court. But at the same time, in India, in the same 2025, there are parallel challenges against the same provision, against the same section 69. This is for illustrating this, for supporting our claim on this only, we have stated about the Vimal Vijay versus State of Kerala 2025 case, my lords.
Where a provision in a central legislation is held unconstitutional by a High Court,
Yes, my lord.
whether that operates as a principle across the nation or it is confined only to the particular state.
No, my lords, it cannot be applied all over the nation, because if another High Court says the decision which is contrary to that High Court, it will be confusion, my lord. It cannot be applied to the whole of the India, my lords. My lords, and another question regarding redundant was asked to my co-counsel. Redundant means repetition. This section 69 is a mere repetition of what is said under section 63 read with 28. So, as per on the ground of redundant, this section is invalidated and rendered as an unconstitutional provision, my lord. The ultimate aim of rendering it as redundant is to declare that provision unconstitutional. Redundancy is not the decision of High Court. The ultimate decision is the invalidating that provision by making it unconstitutional. Redundancy is the ground used, my lord. My lord, but based on the facts, my lords, there was another question to my co-counsel regarding the special leave petition that Supreme Court has the power. My lords, my co-counsel have stated that the leave that is, my lords, Adviti have failed to seek leave before filing the appeal in High Court of Andhra Pradesh. That is what my co-counsel have stated. Before an victim prefers an appeal before any High Court, they must seek an appeal through seek an special leave. After seeking that leave only, they can proceed with the proceedings of appeal, my lords. That is what my co-counsel have stated. My lords, if my lords are clarified, may I move on to my issues? Much obliged, my lords. My lords, the fourth issue that is yes, my lord.
A matter decided by the Supreme Court under Article 136. Here it's clearly mentioned, in view of the importance of the matter, we cannot have applied for transfer of the matter to the Supreme Court.
Yes, my lord.
For transfer of the case from High Court to the Supreme Court.
Yes, my lord. Yes, my lord.
Has the Supreme Court power to accept such transfer? If so, under what conditions and under which provision of the Constitution?
My lords, the Supreme Court has the power to accept the transfer petition that is filed by Vikyat under 139A Class 1 itself. Because 139A Class 1 says two conditions to file a transfer application under it. First one, as I already stated, the question of law must be similar and substantial question of law must be pending before that Supreme Court and one or more High Court, or that must be pending before 2 or more High Courts. As per the facts given, we agree that it is pending only before the High Court of Andhra Pradesh. But this is a newly enacted provision, so there might be a chance of parallel challenges. No, my lords. I am proving, sorry my lord, sorry for interpreting. I am proving the chance through Vimal Vijay case, my lord. I am not assuming the chance. I can prove the chance through the Vimal Vijay case which has been recently filed in Kerala. So that is why I humbly...
You are interpolating something into the facts, okay.
Yes, my lord. My lords, may I proceed with the fourth issue? My lords, the fourth issue is whether section 69 of BNS is redundant in light of section 63 read with 28. My lords, it is humbly submitted that section 69 is a redundant provision, my lord. To understand its redundancy, first let me summarize what this provision says. First, under section 69 penalizes a man who involves in a sexual intercourse that is obtained through any deceitful means, including false promise to marry. For easy understanding of this bench, accused actively makes a false promise to marry. Sexual intercourse takes place and later that woman discovers that she is deceived. My lords, we have to keep two important components under this provision. First one is perpetrator's evil intent to deceive that woman. Second component is victim's innocence in believing a false thing. These are the two important components under section 69, my lord. Next, in section 63 class 2 read with 28A. My lords, in 63 class 2 penalizes a sexual intercourse as rape when it is obtained without the consent of the victim. But in section 28A, this provision invalidates a consent that is obtained through a misconception of fact. So when these provisions are read together, as per this provision, when a consent is obtained through a misconception of fact and based on the consent the sexual intercourse have happened, then that sexual intercourse can be punished as rape under section 63 read with 28, my lord. For easy understanding of this bench, victim has a false belief or a misunderstood something. For example, victim have misunderstood that the perpetrator will marry her. Perpetrator came to know about the misunderstanding and the false belief of the victim and uses it in favor of him to get the consent for sex. My lords, they have sex. Later she realizes that perpetrator never intended to marry her. The core of this provision also says the same two components. First one, perpetrator's evil intent to deceive and sexually exploit the victim. Second one is innocence of the victim who was unaware of the real face of the perpetrator. The same two components, my lord. My lord, it is humbly submitted that both the provision criminalize same mischief. The only slight variation is, as per section 69, accused initiates the false belief by making a false promise. But as per section 63 read with 28, this provision literally means that the accused maintains the false belief, maintains the misunderstanding of the victim in order to get her consent for sex.
Section 63.
Yes, my lord.
The title of section 63 is rape. Okay?
Yes, my lord.
Rape.
Indeed, my lord.
Defines. Then next section, punishment for rape.
Yes, my lord.
Section 69 doesn't speak of rape.
Yes, my lord.
It speaks of sexual intercourse
Yes, my lord.
by employing deceitful means.
Yes, my lord.
This is the title.
Yes, my lord.
So rape is different. Rape is different offense.
No, my lord. Yes, my lord. Yes, my lord. Sorry.
Rape is a different offense.
Indeed, my lord.
Under 63,
Yes.
defined under 63,
Indeed, my lord.
punishable under section 64.
Indeed, my lord.
Whereas 69 creates another offense, and there it doesn't mention the word rape.
Yes, indeed,
It
my lord.
mentions the word sexual intercourse by employing deceitful means, etc.
And it's need, my lord.
So this is altogether different. You can't say this is redundant because of the rape. This is not rape. 69 is not being punished for rape, which may, if the such reports not amounting to the offense of rape.
Yes, my lord.
In fact, 69 punishes not rape, which doesn't amount to rape.
Yes, my lord.
Sexual intercourse, which doesn't amount to rape, is punishable.
Yes, my lord.
Their rape is punishable. So these are two distinct offences.
Yes, my lord. A clarification for my lords.
Yeah, please.
My lords, I agree that there are two different headings under two different provisions. But what I am trying to say is the offence, the essence of offence and the components of offence under these two different headings are same. That is what I am trying to say, my lords. It is mentioned under a different headings, under a different provision. But the components of the offence, the elements of the offence under both these provisions are same.
In case of rape, sexual intercourse takes place without consent.
Yes, my lord.
In this case, sexual intercourse takes place with consent.
Yes, my lord.
But two different offences altogether.
That is why we read the rape class was 28 class, my lord. The rape under section in the provision of rape, section 63 class 2 defines that when it is obtained without her consent. Without her consent means against her consent, my lord. When the word consent in section 63 class 2 is interpreted by using 28 class A, my lord. Section 28 class A invalidates a consent when it is obtained through a misconception of fact. So when the word consent in section 63 class 2 is invalidated, it is best suitable to punish under rape class itself, my lord.
I agree it may relate to rape, but it's not rape. One is sexual intercourse without consent, the other is sexual intercourse with consent.
When the
These are two different acts, different offences. So you can't say one is redundant because of the other. Okay, go ahead.
Yes, my lord. My lord, it is the variation that is made under these provisions is illusory and artificial, because in both the cases, perpetrator acts with the same mens rea and the victim suffers the same, my lord. My lord, if I would like to highlight a grave unacceptable classification that is made under section 69. Section 69 unacceptably classifies by reducing the severity of the same punishment, same offence for the same crime. If prosecuted under section 63 class 2 read with 28A, the punishment is given under section 64 class 1. The accused can get a minimum of 10 years rigorous imprisonment and up to a maximum of lifetime imprisonment.
Without consent, more punishment. With consent, less punishment.
Yes, my lords, but if prosecuted under section 69, he can be imprisoned for a maximum of only 10 years. My lords, this Honorable Supreme Court in State of Uttar Pradesh versus Naushad 2013, page number 41 of the compendium submitted, my lord, clearly convicted the accused of rape by false promise for the same offence, rape by false promise, for a lifetime imprisonment, lords. Why should this punishment of this much serious offence must be brought down from lifetime imprisonment to a maximum of 10 years?
That's Parliament's wisdom. That is the wisdom of the Parliament. Okay? It's not for you and me. Go ahead.
Therefore, my lords are humbly requested to uphold the decision of High Court that is made under section 437 of BNSS and confirm the redundancy of section 69 and to invalidate it. My lords, if you are satisfied with my submissions on fourth issue, may I move on to the fifth issue? Much obliged, my lords. My lords, the fifth issue is whether section 69 of BNS is constitutionally valid or not. My lords, it is humbly submitted that section 69 is ultra vires to our constitution as it violates the fundamental rights that is guaranteed to the citizens. My lords, firstly, the redundancy of section 69 can violate the right to equality guaranteed under Article 14. Even if the Parliament enacted it, and even if the Parliament has the power to enact it, this provision creates a distinction between the accused, my lords. My lords, section 69 classifies the false promise as a separate offence, but it is best suitable to punish under the rape clause itself, my lords. Both these scenarios have the same harm, same mens rea, and the same effect on consent. As stated in...
Do you say that rape also is unconstitutional because only men are punished and not women are punished?
No, my lords, I don't claim that.
You don't?
No, my lords, I don't claim that.
Do you agree that this discrimination is valid? Classification is valid? Only men can be punished for rape and not women?
My lords, because the as per the definition of rape, only men has the physical ability to rape a woman. Woman cannot rape a man through her physical ability without the consent of man. That is why rape is a special protection for women, my lords. Yes, my lord. Much obliged, my lord.
All this. The good point in this case is the sessions get held, and there is already a provision attracted 63 and 28.
Yes, my lord.
And then he thought that 69 is redundant.
Yes, my lord.
Then the High Court agreed with him that 69 is redundant.
Yes, my lord.
Was he confident to acquit the accused without trying him for 63 and 28?
Yes, my lord. Because the...
That is the more question.
Yes, my lord. Yes, my lord. My lords, I would like to humbly submit that the base on which the prosecution, base of the prosecution is invalidated. On what provision will the prosecution will continue? On what provision will the trial continue, my lord? Section 69 is invalidated. So the base itself have been broken. And that is why Sessions Court have acquitted Vikyat, my lord.
Sessions Court said 69 is redundant because there is already a provision.
Yes, my lord.
While 69 is removed, does the original provision of 63 go? Has the Sessions Judge said that 63 is not applicable, 69 is also not applicable? That is not what the Sessions Judge said.
Yes,
The
ma'am.
Sessions Judge said there is already a provision.
Yes,
That
ma'am.
means 63 that will 28 takes out a case on the facts, but 69 is redundant.
Yes, ma'am.
69 is held to be redundant. Does it result in the acquittal of the accused for the entire case?
No, my lord, he cannot be acquitted under section 63 automatically when 69 becomes redundant. But it is the duty of the prosecution to reframe the charges and file another FIR under section 63. The prosecution have failed to do so.
It is not class.
No.
Charges can be altered at any stage.
Yes, my lords.
See, you can prosecute under 63 only if the report is without consent.
Yes, my lord.
So here you cannot prosecute with consent, when it is with consent.
But when under section 63, when it is read with 28.
69 doesn't amount to rape.
Yes, my lord.
It's not rape.
Yes, my lord.
Yeah. Yeah.
Well, my lords, I will humbly request this bench to refer the article published by PMF IAS, page number 69 of the compendium. Overlapping language can result in unequal treatment, violating the right to equality that is guaranteed under Article 14. This is my claim, my lords. My lords, it is a settled law that arbitrariness is an independent ground to invalidate a legislation. Section 69 arbitrarily reduces the severity of the punishment for the same offence that is listed under section 63 with a suitable punishment. This reduction of punishment is manifestly arbitrary, my lords, as it has no determining principle but irrational and capricious in the eyes of law. Your lordship, as stated in Navtej Singh Johar versus Union, no protection for the other genders. How is it valid in the eyes of law? How it can be a fair law and sustain under our Indian Constitution, my lord? My lord, this is not theory, but is evident from the case Bhupesh Thakur versus State of Himachal Pradesh 2024, page number 88 of the compendium, where the High Court of Himachal Pradesh was unable to protect the transgender woman under section 69 only because of her gender that she is transgender. Only based on the gender, the High Court of Himachal Pradesh has dismissed the case under section 69, my lord. So it is humbly submitted that section 69 is nothing but a bias law, my lord. My lord, thirdly, it is humbly submitted that
They say 15, not 15, 3, 2. Protects women.
yes, my lords.
Special provision for women and children.
Yes, my lords.
Permit.
That is what I have previously stated. A special protection can be made to the vulnerable section, which is women and children. But there should be a minimum data which shows that women are only being deceived and only men are the deceivers. If there is some data shown by the legislation and if there is some data published by the legislation to enact this provision, it is justifiable. Without any data.
Notion of the Constitution is the data that is available for the legislature to act upon.
Yes, my lords.
That would be really required.
But this is only based on the gender stereotype, my lords. This is based on the traditional gender stereotype, based on only the assumption, not the fact of this case. If, as I already stated, that if there is a provision which criminalizes a woman for making a false promise to a man, that
Why the court declared 494 as unconstitutional?
adultery, it seems, my lord.
Adultery.
Yes, my lord. Because it is violative of the right that of the persons who involved in it.
Same principle to this.
Yes, my lords. It also only criminalizes man and leaves the woman, my lord.
The subtlety of the problem should be known.
Yes, my lord.
Vicharth did not say that 69 of BNS is not applicable. He did not say anything before the trial court. During the course of trial, Sessions judge made a reference.
Yes, my lord.
Well, I'm not questioning the reality of the reference. The reference is on the ground of redundancy, not unconstitutionality or gender
Yes,
discrimination, or Article 14, Article 19, or any other, or Article 25. So, then the High Court said it is redundant. Then, was the Sessions judge justified in acquitting the accused in toto? Because he proceeded on the assumption that 63 is applicable, that with 28, and therefore 69 is redundant. Then how is it that on the basis of the reference, he acquitted the accused in toto without concluding the trial on the basis of 63 and with 28? Because that is the basis, very basis on which he made a reference. Now, the victim was not a part of any of this. She was not a party to the reference. She was not a party to the answer to the reference by the High Court. Therefore, was she not justified in making the appeal? Because the acquittal which you are referring to, which has to be appealed under 413 with permission, is an acquittal on trial. Here, the acquittal is not on the basis of trial, it is on the basis of holding that 69 is redundant. Then what is the remedy of this woman?
My lords, before, my lords, with your permission, may I answer? My lords, before going for an appeal based on an invalid provision, they should be intent. It should be false while making itself.
Revealed after breaking only.
Sorry, my lord.
That is revealed after breaking only.
But it is the duty of the prosecution to prove that it was malified from the intent, my lord.
So it can be easily presumed that the intention is since inception.
No, my lords, there is a difference between mere.
Can I read 69?
Yes, my lord.
Sexual intercourse by employing deceitful means, etc.
Yes, my lord.
Whoever, by deceitful means or by making promise to marry to a woman,
Yes, my lord.
by making a promise to marry to a woman without any intention of fulfilling the same action, say, this is the second action, that's what I mean. The second component is refusing to marry a woman without any intention of fulfilling the same promise. That is two different second ingredient specified.
My lords, where is it?
One deceitful promise, the other is refusal to marry.
My lords, I can't find where it is mentioned that refusal to marry. Can you say the exact wordings, my lord, for my clarification?
Whoever by deceitful means
Yes, my lord.
or by making promise
Promise to marry a woman.
to a woman
Yes, my lord.
without any intention
Yes,
of
my lord.
fulfilling the same.
Yes, my lord.
Yeah, that's all. He made a promise to marry
Yes, my
a
lord.
woman without any intention to fulfilling the same.
Yes, my lord. That is the promise to marry without any intention to fulfill the same.
Yeah, that intention not to marry came only after the act came into force.
My lord, if the intention to not to marry came only after the commencement of BNS, it is not even punishable, my lord. It must be, he must have an intention not to marry while making the promise itself. If this intention come to him after the commencement of BNS, it is not punishable, my lord. It should be a deceitful intent from the beginning, not after the commencement of BNS. If it is after commencement of BNS, it is not punishable because the condition prescribed in the under section 69 is not satisfied, my lord. Much obliged, my lords.
As per the problem that is given,
Yes, my lord.
when did he express his disinclination to marry?
My lords, by the starting of 2025.
10 years after.
My lords, secondly, it is humbly submitted that the promise to marry was genuine at the inception, so it cannot be termed as false promise. The core requirement under both these provisions, section 63 as well as section 69, is to prove the intention to deceive at inception, which the appellants have never proved till now. My lords, my question here is, why should Vikyat keep his relationship public? Both the parents were aware of their relationship. Secondly, why should he jointly purchase a house to live with her in future? My lords, if he never intended to marry, why should he do such things? These things clearly prove that Vikyat planned his future with Adviti and acted only in accordance to that. But from early 2025,
Purchasing a house maybe to continue to live even without marriage.
but my lords,
Need not be.
But my lords, the purchase was made jointly, not only by him. They both invested in the house.
To live together without marriage.
Anyways, my lord, if they even if he even wanted to live with her without marrying, it is also proving that he planned to live with her. So it cannot be said that he made a false promise in 2015. Much obliged, my lords. My lords, these things.
It's not the war of celibacy and empty war, because if you live with her, you have intercourse, and after 10 years he says, I want to play sacred. Is it not an empty war?
My lords, that is what I am submitting now, my lords, in my next point. But from early 2025, something had made him to turn religious. He might had an heartbreak in their relationship, or an apathy, or any distress in their relationship, my lords. It is not mentioned in the facts, but these are the usual reasons for which a man will move towards celibacy. My lords, the reason for which he moved towards celibacy is protected under his privacy, dignity and bodily autonomy that is guaranteed under Article 21 of the Constitution, my lord. My lord, next it is a clear law that it is the right for every citizen of India to follow or unfollow any religion or any religious belief. This is protected under Article 25 of the Constitution. If the appellants claim that his religious transformation violates the fundamental rights of Adviti, let them justify it, let them prove it. The burden of proof is on them, my lords. My lords, as stated in Mahesh Damukare vs. State of Maharashtra 2024, page number 109 of the compendium. Today there is a worrying trend of invoking criminal jurisprudence when the relationship turns sour, when the relationship fails. And the Supreme Court have affirmed that human emotions are unpredictable and dynamic in nature in this case, my lord. My lords, it is humbly submitted that criminal law do not punish mere change of mind, and the appellant have failed to prove that Vikyat had a malafide intent while making the promise itself, which qualifies Vikyat to be acquitted under both these provisions, both under section 63 and 69, my lords. My lords, thirdly, it is humbly submitted that relationship was long-term consensual relationship, and the consent of Adviti was not solely based on the promise that is given by Vikyat. Adviti is a highly educated law graduate. She knows the consequences of this intimate relationship, and she knows the consequences if this relationship fails. So it cannot be said that Adviti gave her consent only based on the promise given by Vikyat. This makes both the sections, section 63 and section 69, inapplicable to convict him. In the case of Mahesh Damukare versus State of Maharashtra, 2024, page number 108, the Supreme Court have held their opinion that longer the duration of relationship makes it consensual and not based on the promise that is made by the partner. Therefore, it is humbly submitted that Vikyat can neither be convicted under section 69 nor under section 63 read with 28, my lords. My lords, if you are satisfied with my submissions, may I move on to the prayer? Much obliged, my lords. My lords, wherefore, in light of the facts and circumstances of the case, the legal submissions advanced and the authorities cited herein about is most humbly and respectfully prayed that this Honorable Supreme Court of India may be pleased to allow the transfer petition filed by Respondent Vikyat, dismiss the appeal filed by the appellant Adviti, and reject the impleadment application filed by Women Power NGO, and declare that section 69 of BNS is redundant, and uphold the decision of High Court under section 437 of BNSS, and strike down section 69 of BNS as being manifestly arbitrary and unconstitutional, and uphold the acquittal of Vikyat by holding that section 69 of BNS is not satisfactorily enough to convict him, and or pass such further or other orders as this Honorable Court may deem fit and proper in the interest of justice, equity and good conscience, and for this act of kindness the Respondent as in duty of shall forever pray, my lords. Much obliged, my lords.
Not legally, Your Lordship, but the council would like to stand their ground on the cost title of the Your Lordship, the council would like to raise just one rebuttal based on the cost title of the case, because that goes into the legal root of this entire factual matrix, Your Lordship. Your Lordship, the counsel for petitioners humbly submit that Vikyat is the petitioner in this instant case, because the council will be dealing with this in two petitions, Your Lordship, with respect to the factual matrix and with respect to the legal provisions, Your Lordship. Firstly, Your Lordships, if we look at the 6th para in the Moot proposition, if the council may read, in view of the importance of the matter, Vikyat has applied for the transfer of matter to the Supreme Court. The Supreme Court, while getting the case transferred, has constituted a 3-judge bench of the court to hear the matter. Adviti contested her transfer of her appeal to the Supreme Court. Your Lordships, here inherently two distinct facts prove that Vikyat is the petitioner before this Honorable Court. That is, the fact explicitly gives that Vikyat has applied for transfer before this Honorable Court. And furthermore, Your Lordships, when we take the third line into consideration, Adviti contested her transfer of appeal. When somebody is contesting in legal terms, it means that they are opposing the transfer. Therefore, it inherently makes them the respondent of the case. How can a petitioner or an appellant before this Honorable Court contest their own petition, Your Lordships? That is not legally satiable, Your Lordships. That is with respect to the factual matrix of the case. The friendly counsel has time and time again cited Article 139A, particularly Clause 1, as the jurisdiction of this Honorable Court. if the council may read the particular provision for the convenience of the bench, the proviso of this particular article clearly states that provided that the Supreme Court may, after determining the stat questions of law, return any case so withdrawn together with a copy of its judgment on such questions to High Court from which such case was withdrawn. So it clearly states that it clearly creates the distinction between a transfer of an appeal and a transfer of a petition, your lordships. Here, your lordships, this honorable court is seized with respect to the deciding constitutional validity and redundancy of section 69 because these are inherently constitutional questions which has arisen as a course of the implete petition, your lordships. And this court, as the constitutional court, is the apex decider of constitutional validity. And your lordships, this is also reinforced in the factual matrix of the case because it has been explicitly given that Women Power, a voluntary organization that strives for the rights of the women, filed an implete petition before the High Court, prayed for upholding the constitutional validity of section 69. And in view of importance of this matter, Viket has filed the petition. So, the transfer jurisdiction arose because the constitutional validity of section 69 was challenged. And this also satisfies the legal threshold under article 139A, which says that when there is a substantial question of law, the transfer jurisdiction can be invoked. But the same provision also states that after deciding such substantial questions of law, in case of withdrawal from High Court, that judgment of this court on such substantial questions of law may be reverted back to the High Court, where the High Court will be deciding, your lordships. This is also coherent with section 21 of BNSS, which states which recognizes the courts which are competent to try offences, your lordships, and it only recognizes 3 courts, which is the High Court, the Court of Session, and the Court of Magistrate, your lordships, and it does not inherently recognize Supreme Court as a court of trial. While this honourable court enjoys criminal jurisdiction under 134 for appeal, and it may also allow for special leave for petition under 136 with respect to transfer jurisdiction, because that is the entire jurisdiction of this case, it can only decide substantial questions of law, and it is not with respect to the appeal, your lordships. It is not with respect to the factual posture of the case, rather the substantial question of law that has arisen due to the factual posture of the case, your lordships. And furthermore, your lordships, to substantiate the same, the council will be submitting a transfer petition that is currently pending before the Supreme Court, where the cause title before the High Court was the accused, sorry, your lordship, it was the state, that is the prosecution versus the accused. This was the initial cause title before the High Court, your lordship, state versus Jyoti. However, your lordships, in this particular case, Jyoti, who is the accused, has also sought a transfer petition before this honourable court, and the honourable court, while recognizing this order, it has given an office report which clearly states that the transferor will be recognized as the petitioner in the case. Even though the cause title before the High Court was state, that is the prosecution versus the accused, when it got transferred to this honourable court, this honourable court in its office report has given the cause title as Jyoti petitioner versus state of NCT and of Delhi and others. That is the initial prosecutor in the appeal, your lordship, as the respondents. This further proves the legal position with respect to transfer petitions, your lordships, because a transfer petition, even though it may arise out of a case that is already pending, your lordships.
Appeal would have been sufficient instead of transfer. By all these legal complications of transfer, an appeal against the decision of the Sessions Court, because it was based on the decision of the High Court, which gave in reference. So a simple appeal could have been enough, because appeal is a matter of right.
Indeed, yes, your lordships.
Matter of right.
But however, your lordships, to proceed with the same, the proceedings before the High Court had to reach finality, and then only the parties can approach this honourable court through appeal. However, your lordships, the High Court in this particular case had already decided the redundancy through reference mechanism. Under the doctrine of functus officio, it states that a judicial authority or any authority of law which has already seized on a matter cannot again dispute the same.
Appeal to Supreme Court against the decision of the High Court. That's what I think.
Indeed, yes, your lordships, and that is why the transfer jurisdiction was invoked, your lordships, and the council will be submitting the judgment to substantiate the cause title, your lordships. Final contention, your lordships, since this case is undecided, and that might again give ambiguity with respect to the cause title. a very landmark judgment, which was a transfer petition before this honorable court, will be cited by the council, your lordships, which is Menaka Gandhi versus Rani Jethmalani. Your lordships, this is a very landmark judgment with respect to loci standi and transfer petition and its jurisdiction, your lordships. It must be noted that the factual posture of that particular case was that Rani Jethmalani had put a petition before the Bombay High Court seeking to convict Menaka Gandhi for the offence of defamation, your lordships. However, the accused in that case before the Bombay High Court was Menaka Gandhi. When Menaka Gandhi sought a transfer before this honorable court, as the transferor of that particular case, she was rightfully recognized as the petitioner in the cause title, your lordships. That is, the final judgment clearly stated that Menaka Gandhi versus Rani Jethmalani, even though Rani Jethmalani was the initial victim before the Bombay High Court, your lordships. Therefore, the contention of the council is that whenever transfer petition of this transfer jurisdiction of this honorable court is invoked, the transferor who invokes the transferee court's jurisdiction is the rightful petitioner, and this is further substantiated by the fact that Adviti contested the transfer. Someone who contests the transfer cannot argue on behalf of the petitioner and appellants, and that further proves the claim that Vikyat is the petitioner in this case.
So finally, according to you, Vikyat is the appellant.
Vikyat is the petitioner before this honorable court, your lordships.
You have heard the case appeal.
Your lordships, that is the.
Have we heard the appeal are only a transfer?
Your lordships.
Already affected. Therefore, the matter is before us. Whether such a transfer is correct or incorrect is one point that is debated. That's all. The transfer of what? Transfer of an appeal. An appeal pending before the court. Now, if Vikyat is the appellant, what relief the Supreme Court has to grant to Vikyat?
Your lordships, Vikyat.
What can he actually pray for us? Pray from us, because he is the beneficiary of the judgment of the session court. He is the beneficiary of the judgment of the High Court. What is the grievance for him before the Supreme Court? There is no grievance at all. In the reference, High Court said provision is unconstitutional.
Grievance is that
The Sessions Court said that
section 63 and 28 are redundant. That's the point on which.
Your lordship, if I may clarify, the clarification that was provided to the participants clearly stated that the appeal. Your lordship, the clarification that was provided to us clearly stated that the appeal against acquittal was challenged before the High Court, and the High Court had allowed the appeal, your lordship. That was, if the council may submit the clarifications, please refer to clarification number 14, your lordships.
Acquitted.
acquittal is contested before the High Court, while the contest is pending, that was withdrawn and was posted before the Supreme Court.
Indeed, no, your lordship. That is what the council is trying to state time and time again. In clarification number 14, the answer clearly states that the High Court has allowed the appeal and the implete petition. So it has been allowed before the High Court. But before the High Court could listen to the case on the merits, before the High Court could listen to the merits of the case, it was transferred, your lordships. Much obliged, your lordships.
Yeah.
My lords,
Yeah, right.
my lords, I could clarify this confusion in a simple line. My lords, my friend counsel has confused the transfer petition with the transferred criminal appeal. This is what the confusion exists here. My lords are kindly requested to refer page number 40 of my memorial. I have given the copy of transfer petition filed by Vikyat in Honorable Supreme Court. I have filed the annexure in the in my memorial itself. My friend counsel also requested to refer it. In the transfer petition under 139A class 1, that is filed before Supreme Court, Vikyat is the petitioner versus Adviti and Woman Power is the NGO. This is clear, my lords. This is in transfer petition. But it is mentioned in the facts that it is transferred as per the facts given. It is transferred to the Supreme Court, which means that the transfer petition is accepted by the Supreme Court. When the case gets transferred, the appeal that is pending before the High Court, the appeal pending before High Court, in that appeal, Adviti is the appellant, versus Vikyat is the primary respondent and State of Andhra Pradesh is the pro forma respondent with Women Power NGO as impleader, as intervener. This title is listed before the Honorable Supreme Court. The title doesn't change. The appeal as it is goes to the Supreme Court. It is as it is transferred, not it is appealed by Vikyat. It is transferred through the transfer petition filed by Vikyat. In transfer petition, I agree that Vikyat is the petitioner, but when the
From where to where?
from High Court of Andhra Pradesh to the Supreme Court.
High Court has already decided the matter.
My lords,
Where it goes from transfer, not pending.
my lords, it is pending. It is
High Court has already decided.
no, my lords, it is clearly mentioned in the facts that the case is pending before High Court.
Where? The High Court has already given its decision, and in terms of the decision of the High Court, he was acquitted. Nothing is pending before the High Court.
My lords, as per the last before paragraph, aggrieved by the decision of Court of Session,
By decision, not pending. There is no pendency there.
my lords, it is the decision of Court of Session, not Court of High Court, my lords. Decision of Court of Session, Adviti preferred appeal to High Court against acquittal and Women Power NGO impleaded. In view of this importance of matter, Vikyat has applied for transfer of the matter to Supreme Courts. That
Where to where?
from High Court of Andhra Pradesh to Supreme Court, my lord.
High Court has already decided.
No, my lords, it is pending before the High Court of Andhra Pradesh. Only when the case is pending, they can file the transfer, my lord.
Right.
Much obliged, my lords.
But we are having an opportunity to retired High Court judges, Honorable Justice S.Chandra garu and Justice Sagar garu, along with retired Principal District Judge Krishna garu and Senior Professor of the Nation, including the entire nation, Professor Rangeja, both four are the judges. Along with me, I am Srinivasa Advocate High Court.
ఒకసారి చూడు దీని సౌండ్ తక్కువ వస్తుంది చూడు ఒకసారి చూడు
Sumit, గీతిక ఓకేనా?
రాజనీతి ఉంది.
ఎవరిది ఇది
రికార్డింగ్
లైవ్
వాళ్ళకి రికార్డింగ్
జేబులో వేసుకొని వెళ్ళిపోయి
వస్తారు వాళ్ళు, ఇబ్బంది లేదు.
హలో సెటిల్మెంట్లో ఏం అవసరం లేదు కానీ వాళ్ళకి ఆ అమ్మాయి మీద వదిలేసి ఇప్పుడు వాలిడేటరీకి టైం లేదు కదా, వాళ్ళ ఇష్టం మనకి వాళ్ళందరినీ గైడ్ చేసుకుంటూ కూర్చోవాలి అంటే అవ్వదు. వాళ్ళు కథల్లో కూడా ఎవరు ఎక్కడికి వెళ్తారు సార్ ఈ టేబుల్స్ మీద ఏం రాదు. ఇప్పుడు వెళ్ళి ఇదిగో పెద్దవి కిందకి వెళ్ళి 7 బాటిల్స్ కిందకి వెళ్ళి పెద్దవి
రెండు మార్చి వాడతాం. ఒకరు ఇటు మాట్లాడుతూ ఉంటే ఒకరు మాట్లాడతాం.
అటు ఇటు పరిగెత్తాలి మేము.
స్టార్టింగ్ అయితే అక్కడే స్టార్ట్ అవుతాం.
ఒకటే మాట్లాడు మనం.
స్టార్టింగ్ అయితే అక్కడే స్టార్ట్ అవుతాం.
లావణ్య లావణ్య
Please listen. Volunteers మీరు కూడా ఒకరు వినండి. డయాస్ కి రైట్ సైడ్ న పార్టిసిపెంట్స్ ఉంటారు. ఆడియన్స్ అండ్ స్టూడెంట్స్ ప్లీజ్ ఇటువైపు రండి. ఆ ప్లేస్ మొత్తం కూడా ఆడియన్స్ కి రిజర్వ్ చేశారు. ప్లీజ్ నారాయణ ఫాస్ట్ ఫాస్ట్. We have only few minutes. Volunteers ఎక్కడయా? చూడండి గైడ్ దాని ముందు వస్తే కూర్చోవచ్చు. ఫస్ట్ మీద కూర్చోవచ్చు. గ్రీన్ ఏరియా సరిపోయిందా? ఎంత ముందు తప్పితే కూర్చున్నారండి. గైడ్ రండి. వాలంటీర్స్ వాట్ ఆర్ యు డూయింగ్? We are requesting that please participants please be seated on the right side of the seats. We are requesting the participants please be seated on the right side. All the participants and the team manager have to assemble in the auditorium. Captain. Team Kanun. All the members have to take your seats. Please take your seats. Good. All the team members and the participants have to be gathered in the auditorium. Team Kanun.
Hello. We start with the valedictory function, and I invite the president of our management committee to come on to the dais and occupy the seat of the president here.
Now I request Honorable Sri Justice M. S.Chandra garu to come on to the dais and to be the chief guest at this valedictory function. And I invite Honorable Justice Sri Kripasagar garu to come on to the dais and to give a small message to the students. I request the Honorable Secretary and Correspondent of the college, Sri V. Kupswami garu, to occupy the seat on the dais. Now we start the program with Vande Mataram.
Vande Mataram, Vande Mataram, Sujalam, Sufalam, Malayasta Sitalam, Sasya Samalam, Mataram, Vande Mataram, Subrajosna Pulakitayamini, Pullakusumita Drumadala Shobini, Suhasini, Sumadura Bhashini, Sukadam Varadam Mataram, Vande Mataram, Vande Mataram.
Now I request the Honorable President of this evening's meeting to give a small message.
Honorable Chief Guest of this Valedictory and CLAT distribution function, Sri Justice M. S.Chandra, retired Judge of High Court of Andhra Pradesh. Honorable Guest Sri Justice Kripasagar, retired Judge of High Court of Andhra Pradesh. Secretary and Correspondent of the college, Sri V. Kupswami, Principal of the college, Dr. S.Chandra, Law Professor, Senior Advocates, Law Officers, members of the staff, members of the participating teams, and dear students of our college students. A very good evening. Our college and the society that sponsor our college are charitable institutions. Philanthropists in and around Moot have started these institutions to promote value-based education. For the sake of education, we keep on doing all the possible academic activity. Conduction of the smooth court competition is such an attempt to promote legal education. Hope we all have a good academic activity yesterday and today on the campus. The judges for the past 2 days worked hard in conducting the competitions. Yesterday's session must be a strenuous session. I personally thank all the eminent people that acted as judges. The Moot Society members and student volunteers in various capacities have made dedicated effort in conducting the competition. Hope the junior batches follow the footprints of the seniors and organize the future events in a far better way. The principal and the staff well supported the students in the smooth conduction of the event. I heartfully appreciate their efforts. Participating team members have traveled from far-off places. Hope you all have present stay in the rooms. We plan to provide the best possible good food. We have taken utmost care in conducting the program in accordance with well-established practices. We collect the suggestions from senior academicians and others and try to improve the conduction of the competition in the years to come. Wish all the students good luck in your career and life. Thank you all. Thank you.
I request Honorable Justice Valedictory to give a small message to students.
అందరికీ నమస్కారం. Very nice and obvious arguments that we have heard. The gentleman must be very brief. I really congratulate all of you for your wonderful work that you have done. The management and the principal, they require special congratulations because this is one process through which an academic lawyer who is aspiring to be a professional lawyer would find his foothold to develop himself. And I really admire all the children who have assembled here, who have been participating all these 2 days in preparing for the topic. Wonderful precedent is quoted, and the questions that are raised by the judges are very well answered. Once you become a professional lawyer, you are required to remember that the team which has prepared the problem and has given it to you on a paper. But in your real lifetime work as a professional advocate, problems do not come on a paper. Problems do come through the mouths of humans with whom you should be engaging for hours together to know what exactly is his problem, and then you will have to document it. That requires a lot of patience. And then, to be successful in your profession, the person who comes to you must initially hold belief in you, and that belief should continue for years to come, and all that depends upon the integrity and ethics that you maintain. I am very sure with this erudition, those who have participated here, those who have attended here, and every other law student will certainly be successful in their life. Thank you very much.
Both the judges are my friends. Now I request my another good friend, S.Chandra, to give a small message.
President of this institution,
R.V.K. Prasad, Secretary, Advocate, Uppuswamy, Secretary of the institution, and 2 other doctors, Dr. Sudhakar Babu and Dr. Vidyasagar. And another doctor is a medical doctor, the president of this institution. But I am not a compounder, I am only a judge, retired judge. But speaking before a senior officer like Vidyasagar, he is senior to me, I am confessing, is a difficult task because he was a lecturer for some time. He knows how to deliver lecture, but I am a poor speaker, I am confessing. Anyhow, today we were on the bench, at least for a few minutes,
and heard argument of two teams from Tamil Nadu only. And I don't know how they started their argument. There are two methods of argument. One is inductive method and the other is deductive method. The inductive method can be said to be a bottom up and the other is converse. But both the teams had neither followed any of these modes of argument. That you must cultivate how to advance argument. But both teams performed well, and I can say they are better than thousands of advocates practicing in trial courts and in high court also. And I don't know how many of the students will settle in profession. At least 50% may settle in the legal profession. Earlier it was known as noble profession, only it is a rich man's profession. Now it become an unemployed profession. Those who do not get any employment are joining in this bar, but my request is at least to who have got potential has to join in bar and advance legal education and educate the judges. Not educating, but actually it is only assistance to the judges to perform their duties. And to be a successful lawyer, one must possess three qualities. One is commitment to the profession. The second one is conviction. The third one is craftsmanship. If you possess all the three qualities, certainly you will become a good advocate. But only present problem is some of the colleges imparting training in different subjects which are not useful in some of the courts, at least even in Andhra Pradesh. Particularly, I am telling some few examples. One is space law. If you study space law, you can't practice in Andhra Pradesh High Court or in Guntur District Court. And corporate laws, the litigation is minimum in Andhra Pradesh. If you go to Hyderabad, you can enjoy the practice even on corporate side also. So therefore, depending upon your place to settle, you can choose the subjects. Now traditional practice has gone several changes and it become hard to practice because every movement of an advocate while appearing before the court is being watched by every client, particularly in the High Court. If you say something or if you miss to submit something, immediately they are calling you by phone and asking you, why did you not submit this? This is the present trend. It is difficult to manage the clients. Therefore, you must be thorough with subject and facts. Otherwise, it is difficult for any of the advocates to practice in the present days when virtual hearing is permitted. And I have seen some of the advocates who are not properly representing while advancing argument by virtual mode. Perhaps most of the advocates are aware, one of the senior advocate in Supreme Court appeared in shorts before the court in virtual mode. This is very bad practice, and even in the high courts also, some of the advocates are appearing while traveling in car and sometimes sitting on the water tank on the upstairs. And one lady advocate appeared while drying clothes on the top of the terrace. This is the bad practice. And there are many instances where the advocates are not maintaining minimum required standards while appearing before the court. This is what at least some of you may go to bar within few months at least. Don't adopt such practices. And most of the students here are female. Even in judicial service also, more than 50% are female. Not 2/3, but more than 50%, I can say. Because I conducted interview as a chairman of the committee about 3 years ago, and 90% of the candidates who attended to the interview were female, not male. Is it due to their inefficiency or for any other reason? I don't know the reason, but it is better to reconcile yourself. Anyhow, today it is a laudable event under the guidance of the president of the institution, conducted by the principal of my senior. He was my senior in college, and he was insisting me to attend to this institution many times, but for different reasons I did not attend to any of the functions. But now I can't explain those reasons, but this become an opportunity for me to attend to this function. Therefore, I'm thankful to the management of the institution, and particularly Mr. Sudhakar Babu, who compelled me to attend to this program. Thank you for giving me this opportunity.
My friend confessed that he was not a good speaker, but I know him as a wonderful judge. Okay, now we take up the pleasant part. I request both of my friends, the honorable judges, to give away the prizes. Please. Now, the winner of the competition gets our President's Trophy, 25,000 rupees cash award, and another prize, and a certificate. Now, the winner is Lex Losi. Please come on. Center girl. The winner gets another prize also. It is for 12,500 given by our former secretary and correspondent and the present vice president, Jagalamudi Murali Mohan Garu. Same. Now the runners-up. Runners-up also will get 2 prizes, and the first prize is the Secretary's Trophy, and it is secured by Canon. 20,000 rupees cash prize, certificate, and a memento. Huh? Wait. And the second prize is instituted by our treasurer RVK Prasad Garu, and it is for 10,000 rupees. So the winner of the best memorial also gets two prizes. One is principal's trophy and an amount of 10,000 rupees, and it is secured by Canon. So they are from Erode Law College. They get another prize also, the prize instituted by me. It is for 5,000 rupees. The best speaker gets two prizes. One is staff trophy, and it is for 10,000 rupees. A memento, cash prize, and certificates. It is Lex Loci. And Tharani is the best speaker. And the second prize is by the members of the staff of this college, and it is for 5,000 rupees. Winner of the researcher test also get two prizes. One is by the alumni of our college, and it is for 10,000 rupees. A trophy, certificate, and cash prize. And it is de jure. And Hitan Gaud. So KLE Law College, Bangalore. And the researcher test winner gets another prize instituted by our old student and officer of ECGC, Export Credit Guarantee Corporation, and it is for 5,000 rupees. Now semi-finalists, quarter-finalists and all the participants will get the prizes and my colleague will do it.
Now, I would like to announce semi-finals list. Team Nyaya Sanhita, Siddhartha Law College, Vijayawada. Speaker 1, Eleprolu Likitha, Rohita Vaji, Chekka Akshaya. Team Nyaya Sanhita, Eleprolu Likitha, Rohita Vaji, Chekka Akshaya. Team INRE, Dr. Ambedkar Global Law Institute, Tirupati. P. Harshita, Kirtana Dasari, Naveen Chandra. Team INRE, Dr. Ambedkar Global Law Institute, Tirupati. P. Harshita, Kirtana Dasari, Naveen Chandra. Now, I would like to announce quarter final list. Team Magister. Team Magister. Riya Jain, Navika Sharma, Shreya Jain. Team Magister. Riya Jain, Navika Sharma, Shreya Jain. Team Liberty. Dr. B.R. Ambedkar College of Law, Andhra University. Harshita Devaguptula. Harshita Devaguptapur. Janapala Anita Rani, Nikshipta. Team Liberty, Harshita, Anita Rani, Nikshipta. Team Gavel, Chennai, Dr. Ambedkar Government Law College. S. Lavanya, Mohana Krishnan, Shahina Parvin. Team Gavel, S. Lavanya, Mohana Krishnan, Shahina Parvin. Team Domicile, Sai Nagalahari, Ritika Solanki, Harshita. Team Domicile, Sai Nagalahari, Ritika Solanki, Harshita. Now, I would like to call upon the participants who came across the nation to argue and who are the winners of learning. So, I congratulate each and every participant and to have their participation certificate. Team Affidavit, Presidency University, Abhimanyu Raja, Sujit Subbai, Nitish Mahendra. Team Affidavit, Presidency University, Abhimanyu Raja, Sujit Subbai, Nitish Mahendra. Team Dictum, ICFI Law College, Hyderabad. Team Dharma, Sestra deemed to be University, Tanjavur, Tamil Nadu, Maheshwari, Ritika, Suresh. Maheshwari, Ritika, Suresh. Team Themis, JSS Law College, Mysore, Karnataka. Kushi Nagasundar, Chinmayi, Leah Maria, Ello. Team Themis, JSS Law College, Mysore, Karnataka. Kushi Nagasundar, Chinmayi, Leah Mario Ello. Team Adalat, the Tamil Nadu Dr. Ambedkar Law University, N.E. Tamil Indian, Sai Venkat, Eleni. Team Adalat, the Tamil Nadu Dr. Ambedkar Law University, Any Tamil Indian, Sai Venkat, Eleni. Team Verdict, Symbiosis Law School, Pune. Priyanka Pillai, Mahak Madhavi, Venya. Team Verdict, Symbiosis Law School, Pune. Priyanka Pillai, Mahak Madhavi, Venya. Team President, Government Law College, Vellore. Shweta, Divya, Shabina. Team President, Government Law College, Vellore. Shweta, Divya, Shabina. Next. Team Vakil, Tamil Nadu National Law University, Santosh Shivan Raghunathan, Agalya, Danish Paul. Team Vakil, Tamil Nadu National Law University, Santosh Shivan Raghunathan, Agalya, Danish Paul. Team Pleader, Naziruddin, Kirtika Chowdhury, Sai Tejashwini. Team Pleader, Naziruddin, Kirtika Chowdhury, Sai Tejashwini. Team Lexfori, Government Law College, Ernakulam. Gautam Jyoti, Anjana, Arya Suresh. Team Lexfori, Government Law College, Ernakulam. Gautam Jyoti, Anjana, Arya Suresh. Team Nyayadish, NVP Law College, Likitha, Gayatri Gaud, Jyotirmayi. Team Nyayadish, NVP Law College, Likitha, Gayatri, Jyotirmayi. Team Attorney, the Maharaj Sayajiro University of Baroda, Krishna Shreyas, Agatya, Janaki Barmendra Bai. Attorney, Team Attorney, Krishna Sayas, Agatya, Janki, Dharmendra Bai. Team The Bench, Government Law College, Coimbatore. Anbu Mukhil, Ilekya, Gokul Raj. Team The Bench, Government Law College, Coimbatore. Anbu Mukhil, Ilekya, Gokul Raj. Team D Jury, KLE Law College, Bangalore, Karnataka. Vinay Kumar, Dhananjaya, SN Hitesh Gowda. Team D Jury, KLE Law College, Bangalore, Karnataka. Vinay Kumar, Dhananjaya, Hitesh Gowda. Next, Team Statute, Government New Law College, Indore. Abhishek Tiwari, Rukmani Kant Kurmi, Jai Mishra. Team Statute, Government New Law College, Indore. Abhishek Tiwari, Rukmani Kant Kurma, Jai Mishra. Team Samvidhan, CMR University School of Legal Studies. Harisan Sharma, Ananya Dash, Mamata AG. Team Samvidhan, CMR University School of Legal Studies. Harisan Sharma, Ananya Dash, Mamata AG. Team Marshall, St. Joseph College of Law, Bangalore. Afsar Ahmad, Sachin, Fiza Banu. Team Marshall, St. Joseph's College of Law, Bangalore. Afsar Ahmad, Prerana Sachin, Fiza Banu. Team Amicus, School of Law, Christ, Bangalore. Sunil Kumar Joshi, Srivastav, Anubhav Pandey. Team Amicus, Sunil Kumar Joshi, Srivastav, Anubhav Pandey. Team Gazette, National Law University, Tripura. Rashi Biswas, Soumya Singh, Oishri Jana. Team Gazette, National Law University, Tripura. Rashi Biswas, Soumya Singh, Oishri Jana. Team The Bar, Government Law College, Thiruvananthapuram. Sri Lakshmi, Chinmaya, Saina Fatima. Team The Bar, Government Law College, Thiruvananthapuram. Sri Lakshmi, Chinmaya, Saina Fatima.
Now I request the honorable members of the management to honor our guests. Now Dr. Sirisha propose vote of thanks.
Respected dignitaries on the dais and off the dais, faculty members, participants, and my dear students, a very pleasant good evening to one and all. Thank you is a prayer which cannot be seen or touched. It can be only felt with pure hearts. I am extremely privileged to propose the formal vote of thanks for this 5th prestigious Moot Court competitions. At the outset, I thank the President of the college, Dr. Rayapati Srinivas Garu, President of today's function, President of Nagarjuna Education Society, former MLC and former Jilla Parishad Chairman for being the backbone of our college and guiding us in all our endeavors. Thank you very much, sir, for your support and guidance. I now take the privilege of thanking the chief guest of today's function, Sri M. Honorable Retired Judge, High Court of Andhra Pradesh, Sri M. Satyanarayana Murthy Garu, for his continuous support and guidance and for his kindness for accepting our invitation and being a part of today's program in spite of his busy schedules. Thank you very much, sir. Your presence has made our day very colorful and memorable. I now extend my sincere thanks to the correspondent and secretary and correspondent, Sri V. Kuppuswamy Garu, for his visionary intuition and leadership. Thank you very much, sir. I now thank the treasurer of the college, Sri R.V.K. Prasad Garu, for his relentless efforts in providing all the necessary resources always and all the time. Thank you very much, sir. Special thanks to you, sir. I am deeply grateful to extend my heartfelt thanks to the principal of our college, Dr. C.H. Sudhakar Babu Garu, for his untiring and strenuous efforts in uplifting the college towards greater heights of academic excellence. Thank you very much, sir. Thank you very much, sir. I now thank another special dignitary, Sri Krupa Sagar Garu, who is also the retired judge, High Court of Andhra Pradesh, for gracing the occasion and for guiding the students. Thank you very much, sir. I'm also extremely thankful to the Vice Principal of our college, Srimati A. Bhanupriya Garu, for her dedication and tenacity in making this event a memorable one. I thank all the members of the management committee, other dignitaries, senior advocates, and other academicians for gracing this occasion. I thank all the faculty members, both teaching and non-teaching, members of the Moot Society, court officers, team managers, volunteers, and all other students for the flawless execution of this event. I thank all the participants from various colleges whose presence has made this event more meaningful. Finally, I thank each and everybody present here and whoever have contributed to this event. Once again, a big thanks to everyone. Thank you all.
I request everyone in the auditorium, please stand for national anthem. Everyone, please have your dinner. The dinner is ready.